Thank you, Mr. Speaker. I rise to speak on Bill C-3, an act to amend the Citizenship Act brought forward by this Liberal government. This bill eliminates the first-generation limit for the granting of citizenship by descent, and it drastically expands the granting of citizenship to persons born abroad who have little to no connection to Canada. In short, this bill is radical, it's reckless, and it significantly undermines confidence in our immigration system. But then again, it should come as no surprise that we have this awful piece of legislation brought forward by these Liberals, because these Liberals across the way, after all, subscribe to a radical, globalist, post-nationalistic ideology. Justin Trudeau infamously said that Canada is a post-national state with no core identity. It follows that if Canada has no core identity, then Canadian identity means nothing and Canadian citizenship means nothing. That is the vision of Liberal Party for this country, Canada being a post-national state. Now, with respect to the background of this bill, it technically arose following a decision of an Ontario Superior Court judge to strike down the first-generation limit passed by the Harper government. And I emphasize that it was technically arising from that court decision. Now, what is the first-generation limit? All it provides for is that only the first generation of children born abroad can acquire citizenship by descent. It was implemented for good reason, to end what amounted to abuses of citizenship by so-called Canadians of convenience. Persons with little or no connection to Canada, persons who had not been born in Canada, persons who had never set foot in Canada in some cases, persons who didn't pay taxes in Canada, had made no significant or any contributions to Canadian society, but who held a Canadian passport. And invariably, when there would be a crisis in their respective country, they would demand that the Canadian government come to their rescue and bring them to Canada. We saw this in 2006 during the crisis in Lebanon, when the government of Canada was effectively forced to rescue 15,000 persons with next to no connection to Canada, almost all of whom returned to Lebanon when the crisis ended, at a cost of $100 million to taxpayers, persons who, of course, would then claim the right to health care, housing, and other benefits afforded to Canadian citizens. That is what the first-generation limit sought to prevent. Now, the Liberals will say, don't blame us. We had no choice. We have this decision of an Ontario Superior Court. Well, the Liberals did have a choice. They could have appealed the decision. That would have been what would be done in the normal course. After all, it was a lower court decision rendered by one judge, striking down a law duly passed by Parliament. But of course, the Liberals didn't appeal the decision because they're motivated by their post-nationalist ideology. Instead, what the Liberals did was use this lower court decision as a pretext to bring forward the radical bill now before this House, a bill that has been accurately characterized as a chain migration bill, a bill that will open the floodgates to persons being able to acquire Canadian citizenship who are generations removed from any meaningful connection to Canada. And it's important to note that while the lower court judge struck down the first generation limit, the judge provided that it is reasonable for Parliament to impose a substantial connection test. In other words, the judge said it is permissible for Parliament to require that someone born abroad applying for citizenship by descent establish that they have some meaningful connection to Canada. What did the Liberals do in the face of that pronouncement? They ignored the judge. They hide behind the decision, but then they introduce a bill with absolutely no substantial connection test. Instead, what this bill provides for is that someone born abroad would be able to acquire Canadian citizenship if only one of their parents had spent a grand total of 1,095 days in Canada. It need not be over a specific period. It need not be over a consecutive point of time. It could be a few weeks here, a few months there, over the span of decades, so long as one parent had spent 1,095 days in Canada before that child was born. And then that child could extend automatic Canadian citizenship to their child if they also spent a grand total of 1,095 days over their lifetime. On and on it could go, generation after generation. Make no mistake about it. What this bill facilitates is intergenerational chain migration. It provides automatic citizenship to persons with virtually no substantial connection to Canada. Automatic citizenship, by the way, without so much as a background check. That's right, persons with criminal records who might pose a threat to national security if they meet the very wide parameters provided for in this bill would be granted automatic Canadian citizenship. It's just crazy. Now, there is a small glimmer of light coming out of committee, and that's because Conservatives brought forward a number of amendments to fix the most problematic aspects of this bill. The Bloc Québécois worked with us, and those amendments were adopted at committee. Among the most significant of amendments adopted at committee is to establish an actual substantial connection test, as provided for in the judgment of the Ontario Superior Court, which the Liberals ignored, and it would provide for a proper background check. Again, common sense. But these Liberals, subscribing to a post-nationalist ideology, have signaled that they intend to strip the bill of these common-sense conservative amendments, and as a consequence, what we will be left with is the same bill that the Liberals initially put before this House. A bill that weakens what it means to be a Canadian, because citizenship ought to be more than a legal status. It ought to be more than having a passport. It is about our shared values interwoven through the history of this country, this great country, including a commitment to freedom, democracy, pluralism, and human rights, as well as our shared responsibilities, because citizenship is more than rights. With it comes responsibilities. This bill, unamended, significantly weakens what it means to be a Canadian citizen and is not supportable. Thank you.
Questions and comments? Questions et commentaires. The Honourable Member for Sarnia, Lambton, Bicashwanog.
Thank you, Mr. Speaker, and I'd like to thank my honourable colleague for an excellent speech as always. He talked about consequences from this bill. One of the consequences that will happen as a result of this bill is that people that get Canadian citizenship because their parents were here at one time and they don't live in Canada, they will then be able to vote in Canadian elections. And Elections Canada allows you to choose which riding you want your vote to count in. And you can see where that might be very problematic from an interference point of view. And so does the member have any comment on the solution that should be applied to fix that problem?
The honourable member for St. Albert Sturgeon River.
Well, the solution would be to keep the Conservative amendments adopted at committee in the bill, which simply harmonize the requirements between applicants for citizenship by way of descent with those who are applying for citizenship through the process of harmonization.
Questions and comments? Questions et commentaires. The Honourable Parliamentary Secretary to the Government House Leader.
Yes, thank you, Mr. Speaker. And we were supposed to be debating this yesterday, but for political reasons that didn't occur to the extent in which it should have. The question that I have for the member is that when you take a look at Bill C3, there is, as the member references, a court decision, a Superior Court decision. There is a timeline, that being November the 20th. I'm wondering if he could provide his thoughts in regards to, does he sense any obligation of the House to meet that particular timeline?
Honourable member for St. Albert Sturgeon River.
Correct. I said process of harmonization. I meant the process of naturalization in response to the member for Sarnia-Lambton. But with respect to the question posed by the parliamentary secretary, look, this is what the Liberals do all the time. They get a lower court decision that they happen to like for ideological reasons. They don't fulfill their responsibility, which is to defend laws passed by Parliament and appeal the decision, and then they say, we're in a bind, we have no choice, we have to move ahead with legislation. It's part of a consistent pattern, and Mr. Speaker, the bottom line is this government should have appealed the decision. They didn't. They brought in a radical, badly drafted bill. We've worked to fix it. Let's get the amendments kept in the bill, and we can move forward on that basis.
Questions et commentaires. L'honorable
The honourable member for Mirabel. Thank you, Mr. Speaker. In his earlier speech, the member for Bourassa gave us a little show. He said that the amendments at committee went against the spirit of the bill. That shows his incompetence and his bad faith. Incompetence, why, Mr. Speaker? Because the member knows very well that the amendments were accepted by the speakership, so they don't change the nature of the bill. And bad faith, because the member knows very well that the judge in the judgment let Parliament latitude to decide what constitutes a substantial link with Canada, as it applies to certain children born outside of Canada. So the amendments at committee correspond exactly, precisely with what was requested of Parliament by the courts, and they also respect the nature and the goal of the bill. So I'd like to know if my colleague agrees with me, and if he thinks that what the Liberals did earlier today in this debate was just simply misinformation to Canadians for political reasons.
member for St. Albert Sturgeon River.
Mr. Speaker, what the Liberals didn't do is respect the ruling because, as the member pointed out, the judge provided for a substantial connection test. That's absent from this bill. What the Liberals did do is create a two-tier system for applying for citizenship. One for those who are applying for naturalization, whereby they have to get a language test, they have to go for a background check, they have to spend a certain period of time in Canada within 5 years. And then the Liberals, on the other hand, for those who meet the wide criteria that they have set out, give automatic citizenship to persons who have no meaningful connection to Canada. What we have done with these amendments is harmonize the process to end a two-tier immigration process and to respect the ruling of the Ontario Superior Court judge, a ruling that the Liberal government should have appealed in the first place.